Good morning, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. This morning, we have what is called an arraignment. And what an arraignment is, it's an opportunity for the court to tell you what you've been charged with, what your options are, and what your rights are concerning your case. The case that you have in this court is a criminal case. Criminal cases are divided into two categories. They're divided into felonies or misdemeanors. Your felony cases are your most serious type offenses, whereas your misdemeanors are commonly referred to as petty offenses. Does not mean that they're not serious. It just means that they're not as serious as a felony offense. And when I use the term serious, what I'm talking about the facts of the case and the possible punishment that a person can receive if they are convicted of the offense. Now, felonies, we have 5 categories, and we'll start at the top and work our way on down to the bottom. We have a capital murder, first-degree felony, second-degree felony, third-degree felony, and a state jail felony. The state jail felony, the range of punishment if you're convicted is a minimum 6 months to a maximum of 2 years in the state jail. Third-degree felony, the range of punishment is minimum 2 years to a maximum of 10 years in the state penitentiary, and a fine up to $10,000. The second-degree felony, if you're convicted, is minimum 2 years to a maximum of 20 years, and a fine that does not exceed $10,000. If you're convicted of a first-degree felony, the range of punishment is a minimum 5 years to a maximum of 99 years to life in the state penitentiary, and a fine that does not exceed $10,000. If you are convicted of a capital murder case, the range of punishment is minimum life in the state penitentiary without the possibility of parole, or death by lethal injection. The case that you have in this court is a misdemeanor case, so you don't have to worry about that punishment. Misdemeanors are divided into 3 categories, and we'll start at the top and work our way on down to the bottom. And at the top, you have a Class A misdemeanor, then you have a Class B misdemeanor, then a Class C misdemeanor. If a person is convicted of a Class C misdemeanor, the range of punishment is by fine only. You only can be given a fine, and the fine cannot exceed $500. You cannot be assessed jail time. You can only be assessed a fine. However, if you fail to pay the fine, or if you had community service, your fine was converted to community service, and you failed to perform the community service, then the court can issue what is called a capias pro fine. That means that there's a warrant for your arrest so that you can sit out the fine in jail. And normally, if you sit out the fine in jail, it's $100 per day. So, for example, if your fine was $500, you fail to pay the $500, that means you have to be in jail 5 days. All right. Now, the next highest misdemeanor is a Class B misdemeanor. The range of punishment for a Class B misdemeanor is minimum 0 days to a maximum of 180 days in the county jail. A fine that does not exceed $2,000, or you could be given both such fine and confinement. If you're convicted of the next misdemeanor, the highest misdemeanor, which is a Class A misdemeanor, the range of punishment is minimum 0 days to a maximum of 365 days in the county jail, which is a year, a fine from $0 to $4,000. Or you could be given both such fine and confinement. Now, as a defendant in a criminal case, you have rights. One of the rights that I'm going to go over is your right to have an attorney to represent you. You have a right to have an attorney to represent you. Now, on the clipboard that has been handed out, the first page is titled Judge's Explanation of Rights to Defendants Without an Attorney. That talks about the attorney, that your right to have an attorney. And it states as follows: as a defendant in a criminal case, you have three options regarding your right to have an attorney. Number one, you may hire an attorney. Number two, if you do not have enough money to hire an attorney, your case will be reset to give you time to hire. Well, if you do not have enough money to hire an attorney, you can request that an attorney be appointed to represent you. If you want to give up your right to have an attorney or waive your right to have an attorney and you want to represent yourself, then that's the third option. So you can hire an attorney, you can request that an attorney be appointed to represent you, or you can represent yourself. If you want an attorney to represent you and you have enough money to hire an attorney, your case will be reset. Reset means you'll be given another court date so that you'll have time to hire your attorney. If you want an attorney, but you do not have enough money to hire an attorney, you would have to fill out what is called a financial questionnaire. The financial questionnaire is the third document on that clipboard. It is titled Jefferson County Affidavit of Indigence. You'd have to fill out the first page of that document and half of the second page. Once that document is filled out, now the bottom portion of the second page, that's for the judge, and the third page is for the judge. So you will only fill out the first page and half of the second page. And then once you fill that paperwork out, the court will determine whether or not you qualify. That is, you meet the eligibility requirements for the appointment of a court-appointed attorney. If you waive your right to an attorney, and that is you want to represent yourself, you'll be allowed to speak to the prosecutor. We have two prosecutors in court. Prosecutors are assistant district attorneys who work for the Jefferson County District Attorney's Office. They are sitting at counsel's table in front of you. Now, you may not speak to the prosecutor about your case unless you first sign a written waiver of your right to have an attorney. The written waiver is the second page on that document. It is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Next, it says, be aware that there are dangers to self-representation. Waiving your right to an attorney and representing yourself may result in a worse outcome for you in your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. If you choose to represent yourself, you may change your mind at any time and request that an attorney be appointed to represent you. At the bottom of that document, in bold letters, it states defendant's choice. Mark initials next to only one choice. If your choice is to hire an attorney, then you place your initials on the first line to the left. If you have already hired an attorney to represent you, then you will place your initials on the second line to the left and the name of the attorney on the line to the right. If you want to request that an attorney be appointed to represent you, then you will place your initials on the third line to the left. If you've already been appointed an attorney to represent you, then you'll place your initials on the fourth line to the left and the name of the attorney on the line to the right. If you want to waive or give up the right to have an attorney and represent yourself, then you'll place your initials on the fifth line to the left and the name of the attorney on the line to the, well, you'll place your initials just on the fifth line to the left. Now, once you have finished initialing one of the 5 lines, then you will sign your name on the line that is titled defendant, and you will place today's date on the line that's titled date, and today's date is January 30th of 2024. Now, for those individuals who will be waiving their right to an attorney and representing themselves, they would have to read and sign the next document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding to trial. And it states as follows: I have been advised of the nature and charges against me and the dangers and disadvantages of self-representation. My waiver is voluntarily and intelligently made. And it states that I have been advised this 30th day of January of 2024 by the County Court at Law number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I am unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I'm not financially able to employ counsel, I wish to waive that right and request the court to proceed with my case without an attorney being appointed for me. I hereby waive my right to counsel. Now, if that is your choice, then you will sign your name on the line that is titled defendant, and you'll place today's date on the line that is titled date. Now, as a defendant in a criminal case, you also have a right to have a trial by jury. That area over there, where there was 12 chairs, or we call that the jury box. 6 citizens from Jefferson County will be selected as jurors in your case. They will listen to all of the evidence and the arguments, and they will deliberate, and then they will decide whether to find you not guilty or guilty of your charge. You also have a right to waive or give up your right to have witnesses to come to court. And by doing so, if you waive or give up your right to have witnesses in your case, then if you waive or give up your right to have jurors or have a jury trial, your case will come before the court in one of 3 ways. One way it comes before the court is by way of a bench trial. A bench trial means that it's a trial by judge only. And the judge will listen to the evidence, the arguments, and then the judge will decide whether to find you not guilty or guilty. The other way that your case can come before the judge is by way of an agreed plea bargain agreement. A plea bargain agreement is an agreement that you work out with the state or with the district attorney's office to settle your case. If you are able to work out a plea bargain agreement, then the case comes before the court or before the judge. And then the judge will decide to either accept or reject your plea bargain agreement. If the judge rejects your plea bargain agreement, then you have the option to withdraw or take your plea back. So for example, let's say you and the state have reached a plea bargain agreement, and the state say, well, judge, we reached an agreement, and the agreement is for the defendant to serve 10 days in jail. And then the judge said, well, I'm not going to follow that plea bargain agreement. Then you say, well, judge, since you're not following the plea bargain agreement, I withdraw, or I take my plea back. You can do that. You have a right to do that if you have a plea bargain agreement and the judge does not follow it. Now, if the judge does follow the plea bargain agreement, then if he follows the plea bargain agreement, then if you decide within 30 days of the plea bargain agreement, after accepting the plea bargain agreement, that and within 30 days after being convicted, that you would like to appeal your case because you think that you've been wrongfully convicted, or the court has made an error by convicting you, then you have to get permission from the judge to appeal your case. And if the judge gives you permission, then your case will go to another court. It will go to a higher court than this court. It will go to the Ninth Court of Appeals, which is located right above us on the 3rd floor. You would have to file the appeal, and then the Ninth Court of Appeal can do one of 2 things. They could either grant your appeal or deny your appeal. If they grant your appeal, they can just simply find you not guilty. Or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your appeal, then you can appeal your case to a higher court than the Ninth Court of Appeals. You can appeal it to the highest criminal court in the state of Texas, which is the Texas Court of Criminal Appeals. You will have to file what is called a pro se petition for discretionary review. Once you file a pro se petition for discretionary review with the Texas Court of Criminal Appeals, they can do one of two things. They can grant your petition or deny your petition. If they grant your petition, they can simply find you not guilty. Or they can send the case back to the Ninth Court of Appeals, or they can send the case back down to this court and order this court to give you a whole new trial. If they deny your pro se petition, then at that point, your conviction will stand. Now, as a defendant in a criminal case, you also have a right to have witnesses to come to court. Witnesses sit in that chair right there where the microphone is. We call that the witness stand. And what witnesses do, they testify. They can testify either for you or against you. And you have an attorney. The attorney can ask them questions. We call that direct examination or cross-examination. Or if you're representing yourself, you can ask some questions, either direct examination or cross-examination. You also have a right to waive, which means to give up your right to have witnesses to come to court. If you waive your right to have witnesses to come to court, then you will not be calling witnesses. It does not mean that the state will not be calling witnesses, because they will be calling witnesses in the case that they have against you. You also have a Fifth Amendment right against self-incrimination. And what that means is you have a right not to testify in your case. So basically, the state of Texas, the government, or the prosecution cannot force you to testify in your case if you invoke your Fifth Amendment right against self-incrimination. Now, you can waive or give up your Fifth Amendment right against self-incrimination. And if you waive or give up your Fifth Amendment right against self-incrimination, you will be testifying in your case. You also have a right to have what we call discovery. Discovery means you have a right to see the evidence that the state has against you. And that means that you have a right to see the documents, the police reports, your statement, witness statements, lab reports. You have a right to see audio recordings, video recordings. You have a right to see any type of instruments that they may have in your case. Now, you also have a right to waive or give up your right to have discovery. That is, you have a right not to see the evidence that the state will be using against you. Now, as a defendant in a criminal case, all of the individuals who are here today for arraignment, you have been arrested. You were placed in jail and you're out of jail on bond. You're either out of jail on what is called a cash bond, which means you paid the full amount of the bond to get out, or you're out on a surety bond, which means you paid a bondsman a percentage of the bond to get out, or you're out of jail on what we call a PR or a personal recognizance bond, which means that you did not have to pay any money to get out of jail. You were released under your own personal recognizance. Every day that you spent in jail, it could be used as credit towards your fine and court cost or towards your punishment. So, for example, if you spent, let's say you and the state have worked out an agreement for you to serve 5 days in jail, and you've already spent 5 days in jail. that means you won't have to spend any more time in jail. Why? Because you'll be given credit for the time that you have already served. Every day that you spent in jail, you get credited at $100 per day that can go towards your fine and court costs. So if you spend 5 days in jail, that's $500 that can go towards your fine and court costs. And so if the state is offering you fine and court costs of $500, you won't have to pay anything. Why? Because the 5 days that you spent in jail has already paid it off. Therefore, you'll be given credit for time that you served, and then so the fine and court costs will be taxed and retired. Now, if the state is offering 7 days in jail and you spend 5, you have to spend 2 more days in jail. Or if they offer fine and court costs of $700 and you spend 5 days in jail, so that's $500. That means you'd have to pay $200. Now, you will be required to pay the $200 on the day that the case is taken care of or disposed of. If you cannot pay the $200, then the court can put you on what is called a payment plan, where you can pay off the $200 or whatever you owe over a period of time, so much each month. Now, even if the court puts you on a payment plan, if you're unable to pay off the fine and court costs because you do not have a source of income, no problem, because the court can convert the fine and court costs to community service. Okay? And so once they convert it to community service, you'll be credited at $12.50 for every hour of community service that you perform. So, for example, in this scenario, that means you would have to 8 hours of community service is $100. So, if you owe $200, you would have to work 16 hours of community service at a nonprofit organization in the Jefferson County area. Okay. Now, Jefferson County District Attorney's Office has a program for first-time offenders. If you've never been in trouble before, Jefferson County DA's office has a program that they will dismiss your case and you can get it wiped off your record. The program is called pretrial diversion. In order to qualify for the program, you have to have an attorney to assist you to get in the program. It has to be your first time getting into trouble. And then it cannot be for an offense involving unlawfully carrying a weapon or resisting arrest. So for all other offenses, you can qualify. And as I mentioned earlier, you get into the program, they dismiss the case, you complete the program, you can get it expunged. Expunged means wiped off, deleted, or erased from your criminal record, like it never happened. And if you're interested in that program, just let the court know, and we will be able to direct you to the person in the DA's office who can help you with getting into the program. Next, Jefferson County District Attorney's Office also has a program that is called Veterans Court. Veterans Court is a program for veterans only. If you are a veteran of any one of the branches of the United States military, Jefferson County District Attorney's Office has a program that's called Veterans Court. It's similar to it's part of the pretrial diversion program, where you get into the program, they will dismiss your case once you complete it, and you can get an expunction. You can get it not expunged, but you can get a non-disclosure. And what a non-disclosure is, it basically means that we cannot disclose to the general public that you had this case. Okay, so it's like your record being sealed. Okay, now when I say to the general public, the government can have access, law enforcement, just governmental entities, but the general public, which is most of the public, cannot have access to it because your record is sealed to the general public. Now, this court also has a program that is called the Community Safety Initiatives, the CSI program. With the CSI program, we have partnerships with local agencies. One of the agencies that we have a partnership with is the Spindletop Center. Spindletop is our local mental health center. And with the Spindletop Center, they will be able to conduct a private interview, and they can do an assessment and develop a treatment plan, either outpatient or inpatient treatment. Now, with that program, the program is designed to address the issue of recidivism. That's what the CSI program is. That's where people commit crimes over and over. And so with the Spindletop program, if a person has some mental health issues, and when I say mental health issues, they can, if a person suffer from just simply depression or anxiety or any host of other mental health issues, then the folks on Spindletop can address those issues through a private interview, an assessment, and they can develop a treatment plan for either outpatient or inpatient. Now, if you're an individual who may have problems with drugs or alcohol, then Spindletop has a program that is called ATAR. ATAR stands for Addiction, Treatment, and Recovery. Also, our local drug and alcohol council has a program that is called OZAR. OZAR stands for Outreach, Screening, and Assessment and Referral. With those programs, the ATAR program and the OZAR program, they're able to do a screening, an assessment, and they can develop a treatment plan for either outpatient or inpatient treatment as well. If you are unemployed or you're simply looking for a better job, then we have a partnership with the Golden Triangle Empowerment Center, who has a partnership with Lamar University. Lamar University has a program that is called CICE. CICE stands for Center for Innovation, Commercialization, and Entrepreneurship. It is a job training program and a job placement program in the hotel industry, the shipping industry, and the chemical industry. Once you are trained in any one of those areas that you select, they will help you to get a job in the area that you're trained in. If you have not graduated from high school, CICE has a program where you can obtain your GED, your graduate equivalency diploma. Now, all of these programs that I've just mentioned, that's through this court, through a program that I started within the first 100 days of taking office in March of 2017, all of these programs are free. It does not cost you or the county anything. Only thing it would cost you is time. And in this court, I like to say we do not just give time, we take our time. And what I mean by that is we do not just simply arrest the problem, we address the problem. And we believe that if we address the problem, we can produce productive people. And if we produce productive people will not commit crimes. Why? Because they have too much to lose. And so, as I often say, when you come to County Court at Law Number 2, we do not just have court as usual, we have unusual court. And it's not because we're different, but it's because we're trying to make a difference in the lives of the individuals that comes before this court, and we're trying to make a difference in the community in which we live. We believe that if we make a difference in the lives of the individuals that comes before this court, we'll make a difference in their home. And if we make a difference in their home, we'll also make a difference in the community, because what comes out of the home goes into the community. So if you're interested in any one of these programs, just let us know. And we have brochures that we can assist you with getting started in any one of these programs that I've just mentioned. The other benefit of the programs is this. All of these programs that I just mentioned, the mental health treatment, drug and alcohol treatment, job training, job placement, GED, all of those programs can be used as community service. So for example, if you cannot pay your fine, we convert the fine to community service. And if you decide to do community service in one of these programs, while you're in that program, you're getting credit for being in the program, you're getting community service hours, and you are also getting the training. The $12.50 is going toward payment of your fine and court costs. So you're doing one thing, but you're getting credit for three. So I like to say you're killing three birds with one stone. So while you're being trained, or while you're getting mental health treatment, or while you're getting drug and alcohol counseling, or while you're in a class for GED, every 1 hour will go to our community service. Every 1 hour will be in the program, and $12.50 will go toward paying your fine and court costs. And so if you're interested in the program, just let us know. Now, we have some individuals here from Spindletop. We have Alex, we have Gabby, we have Deputy Hinton. The folks from Spindletop is going to come forward and tell you a little bit about the program that Spindletop has to offer. Deputy Hinton, Gabby,
Your Honor.
you're welcome. And Alex?
Good morning. My name is Stephen. I'm a mental health licensed state commission here. The sheriff's also here. My coworker, Gabby. Gabby is a qualified mental health professional in this field. The reason we are both here this morning is because the judge cares about every single person who comes before the bench. What the judge has found, what statistics prove, is those who have legal issues commonly have mental health needs, such as use disorders, or sometimes just a lack of community resources to help you with your particular situation.
So when you say mental health problems, it's really just can be simple as anxiety from being in the court. That's common for everybody. Being here, we realize that it's kind of interrupting their lives. We also realize that you have a life outside of this, whether it be a job, kids, family, or something that you're taking care of that this kind of interrupts. So we understand that you have it's chronic sadness. You want to say something like it just kind of damages your spirit a little bit. It doesn't help being here. So whether it be support, whether it be resources, whether it be just being here for you, or even talking to you today, that's what we're here for also.
So for some of you, this may be your first time to be here. Some of you, it may be your 10th time to be here. There's still hope. In fact, what we're offering you today has the ability to change your life, but we're going to need something from you. We're going to need you to share that need with us, and Gabby's going to explain how you can do that very privately.
So this paper that I gave you earlier when you walked in, you kind of filled it out a little bit, said I was going to come back in and talk to you about it. So this paper right here is bound by HIPAA also, which means that the only person who's seeing this paper is me. I'm the only, this paper just allows me to contact you once. I'll send an initial text out to you. If you don't want to respond, that's perfectly okay. If you don't want to receive a text, just specify that you want me to call. Again, it just allows me to contact you once. It's not a robocall. It's going to be from my work phone, and only for me. What I need though is you could put your address and date of birth, but also, it says resource request here. All you gotta do is check a box here. If one of these applies and you're in need of something, you can check it over here. But also if you left the box right here for you also, so if you do need something specific, you can write that in. If you want to talk to me today, there's a box at the bottom down here. Check yes if you want to talk to me privately. No, if you don't, again, this just allows me to contact you once just to see if you even need support, or if you'd like to be in our services, or if you just need resources.
Also, before you leave here today, I want to give this flyer to you. On the back, it tells you some of the advantages of actually participating, but it also has a 1-800 number on there. Should you ever find yourself in an unsafe place, you can call that number and get help immediately. And just shortly, the court is going to go into recess. And when it does, we'll come out there and we'll pick up those documents from you. And I'll also be handing this out to everyone. At that time, we'll be able to visit with you. If you have any questions, we'll be able to answer them. Thank you.
Also, please give a good phone number too. Okay.
Thank you very much. Thank you, Your Honor.
Okay, thank you, Deputy Hinton, Gabby, and Alex. Okay, ladies and gentlemen, the paperwork that you have in your hand, if you need any assistance with filling that paperwork out. We have our court personnel who will be happy to assist you in filling out that paperwork. That paperwork will be picked up from you. Now, before we pick that paperwork up from you, and it's gonna take us a little time to gather all the paperwork and then to put you into the various categories. If you need to use the restroom, there are two restrooms right outside of this courtroom. The men's restroom is in front of County Court at law number 3. And the women's restroom is on the opposite side of the hall in front of the 172nd District Court. Now, please do not leave the courthouse. If you leave the courthouse, then a warrant can be issued for your arrest. You'll be arrested and placed in the Jefferson County Jail. Okay? So at this time, the court is going to, well, just by a show of hands, how many people need help to finish filling out the paperwork? Just raise your hand. Yeah, one. Okay. Okay. So we have our court personnel who's going to come out and help you with that paperwork, as well as the folks from Spindletop. They're going to come around as well, and they may want to talk to you about their program. So at this time, the court will be in recess. Jefferson County Court at Law number 2 is back in session. Court is in session with the arraignment docket. When I call your name, please come forward before the bench. Stand in front of the bench. First case is cause number M313194. Case is styled the state of Texas versus Marco Antonio Patlin. Patlin, would you please come forward? The bailiff assure you where you need to stand. Mr. Patlin, your full name is Marco Antonio Patlin.
Yes, sir.
Mr. Patlin, would you please raise your right hand? Mr. Patlin, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Sir.
Mr. Patlin, you may put your hand down. How are you doing, Mr. Patlin?
I'm doing good. How are you, sir?
I'm doing fine. Thanks for asking. Now, Mr. Patlin, I have before me one document. This document is titled Judge's Explanation of Rights to Defendants Without Attorney. Mr. Patlin, do you recognize this document?
Mhm. Yes, sir.
Okay. Is this your signature on the line that is titled Defendant?
Yes, sir.
Are these your initials on the line that state you would like to apply for, that state you would like to hire your own attorney?
Yes, sir.
Mr. Patlin, before you signed and initialed this document, did you read the document?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in this document true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Patlin, I read your responses. Mr. Patlin, your case is going to be reset. Reset means we'll give you another court date to give you time to hire your attorney.
Sir.
Our court coordinator is going to give you that reset. Once you get the reset from the court coordinator, you'll be free to go and you have a blessed day. Please have a seat in that first chair by the wall.
Yes, sir.
Here you go. Next case is cause number M324356. Case is styled the state of Texas versus Aisha Renata Granger. Please come forward. Your full name is Aisha Renata Granger.
Yes, sir.
Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
I do, sir.
Okay, you may put your hand down. How are you doing?
I'm doing fine. Yourself, sir?
I'm doing fine. Thanks for asking. Now, I have for me two documents. The first document is titled Judge's Explanation of Rights to Defendant Without Attorney. Do you recognize this document?
Yes, sir.
Is this your signature on the line that is titled Defendant?
Yes, sir.
Are these your initials on the line stating that you would like to waive your right to an attorney and represent yourself?
Yes, sir.
I also have another document before me that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea. Do you recognize this document?
Yes, sir.
Is this your signature on the line that's titled
Yes,
Defendant?
Sir. Yes, sir. Yes, sir.
Okay, now, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read? You say, which one you,
Well, I'm not getting a lawyer or nothing, so I understand that part. I'm just gonna represent myself. No, yes, sir.
so you understood what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay. I've read your answers. You'll be allowed to talk to one of the prosecutors in a few minutes. Just go back and have a seat
Okay.
where you were sitting, and then prosecutor come out and talk to you. Next case is cause number 23 CCCR 2244. Case is style of State of Texas versus Arthurius Quentin Holman. Your full name is Arthurius Quentin Holman. Mr. Holman, would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
You may put your hand down. How are you doing?
How you doing?
I'm doing fine, thanks for asking. I have before me two documents. First document is titled Judge's Explanation of Rights to Defendants Without an Attorney. Do you recognize this document?
Sir.
And is this your signature on the line that's titled Defendant?
Sir.
Are these your initials on the line stating you like to waive your right to an attorney and represent yourself?
Sir.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in Trial. Do you recognize this document?
Sir.
And is this your signature on the line that's titled Defendant? Now, before you signed and initialed all of these documents that I just showed you, did you read the documents?
Sir.
Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay? Just have a seat, and one of the prosecutors will come back out and talk to you. Next case is cause number 23 CCCR 2164, case of style of State of Texas versus Sonar Rahman. Good morning. Your full name is Sonar Rahman.
Yes.
You please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? You may put your hand down. I have a document before me that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled Defendant?
It is.
And he got two documents. One document say he wants to apply for a court-appointed attorney, and then he has a waiver. So where's the,
He just needs to white out for court appointment.
Oh,
He didn't change it. May I ask you a question? May I ask?
okay, what's the question?
The question is that I would like to speak with the public prosecutor right now, just to see what the.
You can't, well, we have to go through this process first,
Okay,
okay? Then, once we finish this process, you'll have the opportunity to talk to the prosecutor. But first, the court has to go through this process.
if I change my mind, I can also.
Just like it says in the last sentence, you can waive your right to, and if you change your mind, you can request that an attorney be appointed to represent you. Okay. Now, Mr. Rahman, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without an Attorney. You recognize this document?
I do.
And is this your signature on the line that's titled Defendant?
It is my honor.
Are these your initials on the line that states you'd like to waive your right to an attorney and represent yourself?
Yes, my honor.
I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding in Trial. Do you recognize this document?
Yes.
And is this your signature on the line that's titled defendant?
Yes,
Now, before you sign and initial these documents, did you read the documents?
I did.
Did you understand what you read?
Most part of it, yes.
Okay, what did you not understand?
The only thing that is confused about after talking to the public prosecutor, if I would be able to apply for that court appointed attorney or not.
Okay, let me just read to you the last sentence says, if you choose to proceed without an attorney, that is, if you're representing yourself, you may change your mind at any time and may request counsel from the court. Okay, do you understand that?
Yeah, so one part of the document says that it may refer to as that I'm pleading to the guilty.
Say that again.
On the document, it says that on the top of it says that plead to the guilty or like proceeding to the trial. It's in the box in the document.
That's
Yeah, but
in the box.
yeah.
Oh, that's a different, that just says, okay. In order to represent yourself, first of all, as stated in these documents, you have three options. You can hire an attorney. That's number one. Number two, if you do not have enough money to hire an attorney, you may request that an attorney be appointed to represent you. Or number three, you can waive or give up your right to have an attorney. Right? Those are the three options. And it further states that if you want to hire an attorney, your case will be reset to give you an opportunity to hire your attorney. Now, if the second option, if you do not have enough money to hire an attorney, you would have to fill out a financial questionnaire so that the proper person can determine whether or not to appoint an attorney to represent you. That's the second option. Now, speaking of the third option, it says you may not speak to the prosecutor about your case unless you sign a written waiver of your right to be represented by an attorney. The third option is you may represent yourself, but you can't speak to the prosecutor about your case unless you first sign a waiver stating that, one, I know I have a right to have an attorney. I do not want an attorney to represent me at this time. Okay? I want to represent myself. That's what the third option is saying. And that's what's in the waiver. And if you waive your right to an attorney, you will be representing yourself. And because you are representing yourself, you are acting as your own lawyer. So therefore, you can talk to the prosecutor because you are the defendant and the lawyer. Now, if you did not waive your right to have did not waive your right to have an attorney to represent you, and you will get an attorney to represent you, you cannot speak to the prosecutor. Why? Because you have a lawyer who is not you, who is a different person. So the lawyer can talk to the prosecutor. Do you understand that? So in this scenario, when you say I'm waiving my right to have an attorney, then you're basically saying that I'm giving up my right to have an attorney and I'm representing myself. So I'm the defendant and I'm the lawyer for myself. And so since you're the lawyer for yourself, you'll have an opportunity to talk to the one of the prosecutors or the assistant district attorney. Do you understand that?
Yes.
Now, the other thing is in this document, it talks about the dangers and disadvantages of self-representation, as I read to you earlier. It also states in the last sentence, if you choose to proceed without an attorney, that is, if you decide to represent yourself without another attorney, you'll be representing yourself. You'll waive your right to have an attorney. You may change your mind. In essence, you may change your mind. And if you change your mind, then you can ask that an attorney be appointed to represent you.
Today.
You can, yeah, you'll have, yeah. If you change your mind today, you can ask for for an attorney to represent you today. Okay?
May I ask you the last question before I go? So does signing on that waiver form means that I'm saying I'm guilty of the accusation?
It,
It's only for the waiver to speak with the.
there's no word on here that says you're saying you give. This, at the title, is saying this is a form for waiver of counsel for purposes of entering a guilty plea. So before or prior to entering a guilty plea, if you're representing yourself, you have to sign a document so that the court can verify that this is what you want to do, represent yourself. Okay, so it's like, we don't get the home plate. You know anything about baseball?
No, I do not, sir.
Okay,
I'm not from here, so,
so you know a little bit about cricket.
yes, I know about cricket.
So if you know about cricket, you can't get on the base until you hit the ball,
Right.
right? And so the waiver, you know, guilty, we can't get let's say guilty is the base. Wavering, you hitting the ball, you're saying, okay, I'm waiving my right. Now I can go to the base.
Mhm.
You understand that?
Okay.
Okay. Okay, so let me ask you this here. Okay, I'm gonna go over these documents again. First document is titled Judge's Explanation of Rights to Defendants Without Attorney. Do you recognize this document?
Yes, ma'am.
Is this your signature on the line that's titled defendant?
Yes, ma'am.
And are these your initials on the line that state that you want to waive your right to an attorney and represent yourself?
Correct. Yes, it is, ma'am.
Okay. And this document is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Now, I'm gonna read this document again. I have been advised of the nature and charges against me, okay? So you're charged with fleeing or eluding a police officer. And the dangers and disadvantages of self-representation. And we talked about waiving your right to an attorney may result in the worst outcome for you, including for you and your case, including the loss of significant rights and opportunities relating to military service, possession of a firearm, housing and public benefits, child custody, immigration status for non-citizens, and employment. Okay? And you're saying that my waiver is voluntarily, meaning that you know what you're doing, and intelligently, well, voluntarily means that nobody is forcing you to enter into this waiver. You're doing it of your own free will. That's what voluntary means. Intelligently means you know what you're doing. Now, I have been advised this 30th day of January 2024 by the County Court at Law Number 2 of my right to representation by counsel in the case pending against me. I have been further advised that if I'm unable to afford counsel, one will be appointed for me free of charge. Understanding my right to have counsel appointed for me free of charge, if I am not financially able to employ counsel, I wish to waive that right. Waive means give up that right and request the court to proceed with my case without an attorney being appointed for me. Do you understand that?
Yes, ma'am.
And then you say that, and the next sentence is, I hereby waive my right to counsel, or I hereby give up my right to counsel. There's a signature on this line that's titled defendant. Is this your signature?
Ma'am.
Okay. Now, Mr. Brown, before you signed and initialed these documents, did you read the documents?
Yes, sir.
And do you understand everything in these documents?
Thank you for the explanation. I do.
And is everything in these documents true and correct
Yes,
to the best of your knowledge?
yes, ma'am.
Okay. So, Mr. Robert, just have a seat where you were sitting, and we're going to have one of the prosecutors talk to you about your case.
I appreciate your time and explanation.
Oh, no problem.
Thank you, sir.
Okay, so we have 3 people as the prosecutors. I know. Juan Alvarez? Okay, Mr. Alvarez, does he speak any English?
He understands some.
Poquito?
He said- he said que lo punto de la línea.
He speaks a little English.
No, he doesn't speak any English, he understands some.
He doesn't speak it, but he understands some.
Yes,
Okay. Now, we have Ms. Jennifer Raji, who is. We have Ms. Jennifer Raji, who is in our interpreter. Mr. Raji, would you please raise your right hand? Mr. Raji, do you swear to interpret English to Spanish and Spanish to English shall help you God?
yes, Judge.
Okay. Mr. Raji, ask Mr. Juan Alvarez if his full name is Juan Alvarez. Okay. Ask Mr. Alvarez to please raise his right hand.
Levanta la mano derecha.
Okay. Mr. Alvarez, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God?
Sí.
Yes.
Mr. Alvarez, you may put your hand down. How are you doing, Mr. Alvarez?
Very good.
You're doing very good. That's good. Now, Mr. Alvarez, I have two documents before me. The first document is titled Judge's Explanation of Rights to Defendants Without Attorney. Ask Mr. Alvarez if he recognized this document.
Yes.
Is this your signature on the line that's titled Defendant?
Sí.
Yes.
Are these your initials on the line that state you would like to apply for a court-appointed attorney?
Yes.
And Mr. Alvarez, I also have a document that is titled Jefferson County Affidavit of Indigence. Ask Mr. Alvarez if he recognized this document.
Sí.
Yes.
And Mr. Alvarez, on page 2 of this same document, there's a signature above the line that's titled Defendant Signature. Ask Mr. Alvarez if this is his signature.
Yes.
Now, ask Mr. Alvarez before he signed and initialed these documents, if you, Mr. Raji, went over these documents with him in Spanish.
Sí.
Yes.
And ask Mr. Alvarez, did he understand everything that you went over with him in Spanish in these documents?
Y quiero ver si ellos entendí todo lo que te explicó en ese documentos antes de firmar.
Sí.
Yes.
And ask Mr. Alvarez if he understood everything that you went over.
Y si entendiste todo lo que te expliqué.
Sí.
Yes.
And is everything in these documents true and correct to the best of his knowledge?
Yes.
Hey, Mr. Alvarez, I read your answers. Based on your answers, you meet the eligibility requirements of a court-appointed attorney. And the attorney that will be appointed to represent him in this case is Attorney Charlie Rojas. Attorney Rojas will be given information to contact you, and you will be given information to contact Mr. Rojas. And our court coordinator is going to give you that information. Okay, Mr. Alvarez, just have a seat. And then the court coordinator, do you need to come forward now? Just have a seat in that first chair. Tell Mr. Alvarez, have a blessed day.
He said, you too, thank you.
Okay.
Okay. I'll tell time, but I'm staying with you, I'm showing. Gotcha.
There you go. There you go. Next case is cause number 23CC Ciara 2440. Case is style of State of Texas versus Jermaine Jonkel Johnson. So Johnson, would you come forward? Mr. Johnson, your full name is Jermaine, is that Jonkel
Yes.
Johnson?
Yes.
Mr. Johnson, would you please raise your right hand? Mr. Johnson, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth to help you God? Mr. Johnson, you may put your hand down. How are you doing, Mr. Johnson?
Yeah.
I'm doing fine. Mr. Johnson, thanks for asking. Mr. Johnson, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
Is this your signature on the line that's titled defendant? Or are these your initials on the line that state you'd like to apply for a court-appointed attorney?
Yes, sir.
I also have another document here. This document is titled Jefferson County Affidavit of Indigence. Do you recognize this document? On page 2 of this same document, there's a signature above the line that's titled defendant's signature. Is this your signature? Mr. Johnson, before you sign and initial these documents, did you read the documents? Did you understand what you read? Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
Okay, Mr. Johnson, I read your answers. Based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. The attorney that would be appointed to represent you in this case is Attorney Marva Provo. Attorney Provo will be given information to contact you, and you will also be given information to contact her. Our court coordinator will give you that information. Once she gives you that information, you'll be free to go, and you have a blessed day. Let's see, DWI. Okay, you have a DWI case. Yeah. Okay, now, Mr. Johnson,
Yes.
you're gonna have a seat in that third chair on the wall. And wait for your name to be called by the court coordinator. Once your name is called, you go to her window. Once you finish at her window, you're free to go and you have a blessed day. Okay, court is back in session and calls number 23CCCR 2164, case of style of state of Texas versus Sonora Rama. Mr. Rama, would you please raise your right hand? Mr. Rama, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you
Yes,
God?
ma'am.
Mr. Rama, you may put your hand down. Now, Mr. Rama, I have before me a document that is titled Judge's Explanation of Rights to Defendants Without Attorney. Recognize this document?
Yes, ma'am.
Now, previously, you had stated that you wanted to waive your right to an attorney and represent yourself. However, you have changed your mind. And now you're stating that you would like to have an attorney to represent you.
Yes.
Okay. I also have a document that is titled Jefferson County Affidavit of Injuries. Do you recognize this document?
Yes, ma'am.
And on page, he didn't sign this. Did you get this to him?
I apologize for any inconvenience.
No, that's not a problem. We'll check everything that's being done. We'll make sure it's done right. And Ms. Mosby, you can get that document back to me. Okay, now, Mr. Rom, I have before me Jefferson County Affidavit of Injuries. You acknowledge that you recognize this document, and is this your signature on the line that's titled defendant?
Yes, sir.
Now, Mr. Rama, before you sign and initial these documents, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes,
And is everything in these documents true and correct to the best of your knowledge?
yes,
Mr. Rama, based on your answers, you meet the eligibility requirements for the appointment of a court-appointed attorney. And the attorney that would be appointed to represent you in this case is Attorney Joel Vasquez. Attorney Vasquez will be given information to contact you. And you will also be given information to contact Mr. Vasquez. Our court coordinator will give you that information. Once you get the information from the court coordinator, you will be free to go. And you have a blessed day. Please have a seat in that first chair on the wall.
thank you, sir. Please be upon you.
The same to you. What is he? Let's see. We've gone. Okay. There you go. I think you have to put a number on one of them. Let's see, we have Mr. Jermaine Junko. Oh, he's gone. So we ready on one? Who is that? Holman? Artharius Quentin Holman? Please come forward. Mr. Holman, your full name is Artharius or Artharius? Artharius Quentin Holman. Mr. Holman, would you please raise your right hand? Mr. Holman, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Mr. Holman, you may put your hand down. How are you doing, Mr. Holman? You doing good? I'm doing fine, thanks for asking. Mr. Holman, I have before me two documents. The first document is titled Judge's Explanation of Rights to Defense Without Attorney. Do you recognize this document? Yes, speak up.
Yes.
And is this your signature on the line that's titled defendant? Are these your initials on the line stating that you'd like to waive your right to an attorney and represent yourself? I also have another document that is titled Waiver of Counsel for Purposes of Entering a Guilty Plea or Proceeding to Trial. Do you recognize this document?
Sir.
And is this your signature on the line that's titled defendant? Okay, Mr. Holman, before you signed and initialed these documents, did you read the documents? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Okay, Mr. Holman, I also have before me a document that is titled information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Atharius Quentin Holman, on or about April 1st of 2023, while you were in Jefferson County, Texas, that you committed the Class B misdemeanor offense of duty of striking a fixture on a highway or landscape. Do you understand what you've been charged with?
Sir.
And to discharge, Mr. Holman, how do you plead? Guilty, not guilty, or no contest? Now, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you are guilty?
No,
You're not guilty?
I'm pleading guilty now.
And that doesn't, okay. You're saying two different things.
I'm, yes,
No, my question is, I'm gonna do this again. Okay, you've been charged with the Class B misdemeanor offense of duty of striking a fixture on a highway or landscape. Do you understand what you have been charged with? Now, to this charge, which has allegedly occurred on or about April 1st of 2023, while you were in Jefferson County, Texas, how do you plead guilty, not guilty, or no contest?
Guilty.
Now, are you pleading guilty because you are guilty? Now, Mr. Holman, I have before me another document. This document is on the tablet. This document is titled Misdemeanor Plea Admonishment. Do you recognize this document?
yes,
And on page 2 of this same document, there is a signature, actually the two sets of initials. The first set of initials is on a line that's titled guilty. Did you place your initials on this document? The second set of initials is below a paragraph that is titled discovery admonishment, and it is on a line next to a statement that reads as follows. I do not request discovery of the evidence. I waive my right to request discovery in this case and choose to enter a plea of guilty or no contest. Did you place your initials on this document? And do you understand the statement that I read? On page 3 of this same document, there is a signature above the line that is titled defender. Is this your signature? And on the next document that is titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant?
yes,
At the top of this document, there are two boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? The second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, Mr. Holman, before you signed and initialed all of these documents that I just showed you, did you read the document? Did you understand what you read? And is everything in these documents true and correct to the best of your knowledge? Mr. Holman, are you a citizen of the United States? State, I have before me State's Exhibit number 1. State, would you like to offer State's Exhibit number 1?
Yes, sir.
Do you have, now, Mr. Holman, the state is offering State's Exhibit number 1 to be used as evidence against you in your case. Now, State's Exhibit number 1 is the first document on this tablet. And this document on the second page have your initials that you acknowledge. And on the third page, it has your signature that you have also acknowledged. The state would like to use this document as evidence in your case. Is it all right for the state to use this document as evidence in your case? Okay, no objections. State's Exhibit number 1 will be admitted. Now, Mr. Holman, is there any evidence that you are currently mentally incompetent to stand trial?
No.
Okay. Mr. Holman, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I'll also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. Now, Mr. Holman, what I forgot to mention was that you have a right to have a court reporter to type down everything that's being said. You also have a right to waive or give up your right to have a court reporter. Do you waive or give up your right to have a court reporter?
Yes.
Yes, okay. Now, state, do we have a plea bargain agreement in this case?
Yes, Your Honor.
And state, what is that agreement?
That agreement for a plea of guilty is to plead to a $200 fine plus court costs. And the state is giving 2 days credit based on the time the defendant spent in Jefferson County Jail.
2 days credit?
Yes,
Okay,
Your Honor.
2 days credit toward this fine and court call? Okay, what's the court cost in this case? Okay, now, Mr. Holman, the state is offering that you serve, excuse me, the state is offering that you pay a fine of $200 plus court costs. Now, the court cost in this case is $330. The fine plus court cost is $530. But the state is also giving you credit for the 2 days that you've already spent in jail. So this will reduce, you get credit at $100 per day. So you have $200 credit that is going toward the fine and court cost of $530, which is going to reduce this to $330. Are you able to pay the $330 today? You are? All right. Now, Mr. Holman, do you understand the state's offer? Do you think the state's offer is fair and just? And do you accept the state's offer? Okay, Mr. Holman, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Holman, just have a seat, and the court coordinator is going to call you to a window. And when you go to a window, she's going to give you the paperwork and for you to go downstairs. I think you have a cash bond, you're going to get your bond, you can make your payment, and then you're going to bring that receipt of the payment back up to the courtroom. Do you understand? All right, just have a seat. Next case is cause number 23CCCR 2244. So, no, excuse me. Cause number 23CCCR 2440. Let's see. Well, let's see. Okay, our next case is cause number M324356. Case is filed in the state of Texas versus Aisha Renata Granger.
Yes, sir.
Is that correct?
Yes, sir.
All right. Let's see. Let me pull up your case right quick. Okay, here we go. Okay, your full name is Aisha Renata Granger. Would you please raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Sir.
You may put your hand down. And before we get started, you have a right to have a court reporter to dictate or type everything that's being said.
Yes, sir.
You also have a right to waive or give up that right. Do you waive or give up the right to have a court reporter to type everything or not? Do you understand what I'm saying? You have a right to have a court reporter to sit right here
Yes, sir.
and to type down everything that's being said in this proceeding. But you also have a right to waive, which means you have a right to waive your right to have a court reporter. You don't waive it? You want a court reporter? Okay, let's get a court reporter right quick. Yeah, just have a seat and we'll call you back up. No, she's not even, thought it was something else. All right, let me do this then. Now, I have before me a document that is titled information. This information was filed by the Jefferson County District Attorney. So now I'm looking at it right here on the computer.
Yes, sir.
This information alleges that on or about May 2nd of 2019, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of failure to identify fugitive from justice. Do you understand what you have been charged with?
Yes, sir.
And to this charge, how do you plead? Guilty, not guilty, no contest.
Guilty.
Guilty. Now, are you pleading guilty freely and voluntarily? In essence, are you
Nope.
pleading guilty because you are guilty?
No contest.
Oh, you pleaded no contest.
Yeah.
Okay. Is that on her paperwork? She's pleading no contest.
Read, I just don't understand. Stuff, I don't get in trouble though.
No.
Okay. Okay, so you pleaded no contest?
Yes, sir, Your Honor.
Now, are you pleading no contest because you do not wish to fight or contest the charges? That's what no contest means.
Yes, sir, Your Honor.
And are you pleading no contest freely and voluntarily?
Free.
Okay. Now, I also have before me a document that is titled Misdemeanor Plea Admonishments. Well, actually, this document is titled Judge's Explanation of Rights to Defendants Without Attorney. You recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
And are these your initials on the line that's titled that states you would like to waive your right to an attorney
Yes,
and represent yourself? I also have another document that is titled Waiver of Counsel for purposes of entering a guilty plea or proceeding the trial.
yes, sir.
It's that one. After this. And before you signed and initialed these documents, did you read the documents?
Yes, sir. I
Did you
did.
understand what you read?
Yes, sir.
Is everything in these documents true and correct to the best of your knowledge?
Yes, sir.
I also have a document on the tablet that is titled Misdemeanor Plea Admonishments, also labeled as State's Exhibit Number 1.
No.
Do you recognize this document?
I can't barely see it. Yes, sir. I remember writing on the tab. Yes, sir, I do.
Okay, and on page 2 of the same document, there are 2 sets of initials. One set of initials is on a line next to a box that's checked nolo contendere, which means no contest. Did you place your initials on this document?
Yes, sir.
The second set of initials is on a line below a paragraph that is titled Discovery Admonition or Admonishment. And it is on a line next to a statement that reads as follows.
Yes,
I
sir.
do not request discovery of the evidence. I waive my right to request discovery in this case and I choose to enter a plea of guilty and no contest. Did you place your initials on this document?
Yes, sir.
On page 3 of this same document, there's a signature above the line that is titled Defendant. Is this your signature?
Yes, sir.
And on the next document that's titled Trial Court Certification of Defendant's Right of Appeal, do you recognize this document?
Yes, sir.
And is this your signature on the line that's titled Defendant?
Yes, sir.
At the top of this document, there are two boxes checked. The first box says check states that this is a plea bargain case and you have no right of appeal. Do you understand that statement?
Yes, sir.
Second box that check states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Now, give me that. Those are the two documents I just gave you the way. Judge's explanation. Now, before you sign and initial these documents that I showed you, did you read the documents?
Yes, sir.
Did you understand what you read?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
So, to the best of my knowledge.
Okay. And go back up here. And I also have these other documents that's on paper before you sign and initial these documents. Did you read the documents?
Yes, sir.
And is everything in these documents true and correct to the best of your knowledge?
Yes, sir, Your Honor.
And are you a citizen of the United States? State, I have before me state's exhibit number one, the misdemeanor plea admonishment state. Would you like to offer state's exhibit number one
I do.
into evidence? Now, Ms. Granger,
Yes, sir.
the state is offering state's exhibit number one into evidence to be used against you. Now, state's exhibit number one is the first document on the tablet that I showed to you. It is the same document that have your initials in these two locations and your signature on page 3. Is it all right for the state to use this document as evidence in your case? Okay, no objections. State's exhibit number one will be admitted in court. Will also take judicial notice of the court's file. Ms. Granger, is there any evidence that you are currently mentally incompetent to stand trial?
No, sir.
Ms. Granger, I will accept your plea of no contest. I will find that you are mentally competent to stand trial. I will also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do.
And what is the agreement?
In exchange for the defendant's plea of no contest, the state has offered 9 months deferred adjudication, $250 fine, 60 hours community service, and court costs.
Let's see, what's the court cost in this case?
402.
Okay, Ms. Granger, the state is offering that you serve 9 months on deferred adjudicated probation. During the 9 months probationary period, you'll be required to pay a fine of $250. You'll be required to pay court costs of $402. You'll be required to pay a probation fee of $60 a month, a urinalysis fee of $15 a month, and a reimbursement fee of $15. Your total monthly installments, that is the total amount that you will be required to pay each month, is $168 a month. Will you be able to pay the $168 each month?
It's the max.
Yeah,
Have to, yes, sir.
okay. Now, you will also be required to perform 60 hours of community service.
Yes, sir.
You will also be required to adhere to the other standard terms and conditions of this probation. Now, do you understand the state's offer?
Yes, sir.
Do you think that the state's offer in your case is fair and just?
Yes, sir.
Do you accept the state's offer?
Yes, sir.
Okay, Ms. Granger, I'll follow the plea bargain agreement that you have entered into with the state. Ms. Granger, if you successfully complete this probationary period, this case will be dismissed. It would not result in a conviction on your record, and you may qualify for non-disclosure. You can talk to an attorney about the non-disclosure. Now, Ms. Granger, you're gonna have a seat in the chair, the first chair on the wall, and once the court coordinator is ready for you, you go to a window, you finish at a window, you're free to go,
Oh,
and you have a
thank
blessed day.
Have a good day.
All right, same to you. You have a blessed day as well. And this, yeah, this will conclude the calling of the court's arraignment docket on today's date of January 30th, 2024, in County Court at Law Number 2, Jefferson County, Texas. Judge Terrence L. Holmes presiding. Everyone, please have a blessed day.